That's question number 5.
Yep. This question is prompted by the Celtic Media acquisition, and it questions where there's a significant interest test, if there's an anomaly in the legislation in relation to the Competition and the Consumer and Competition Authority Act 2014, where in situations where it has exceeded the 20% market test.
Minister.
Thank you, Deputy Murphy. The Competition and Consumer Protection Act of 2014 gives the Minister for Communications, Climate Action and Environment responsibility for assessing proposed media mergers and empowers the Minister to prevent any merger that is deemed likely to be contrary to the public interest in maintaining the plurality of media in the state. There is no retrospective element to this legislation. Attempting to intervene in the operation of a media business where no merger is planned would be difficult, and given the purpose of the legislation is to safeguard media pluralism, it is also likely to be counterproductive. Applying a retrospective element to legislation would effectively mean empowering a government minister to interfere in the operation of any media organisation at any time. And this would give rise to a number of difficult questions about preserving the freedom and independence of the press, even before one considers the legal and constitutional complexities associated with retrospective action of this kind. In my view, the reforms introduced to the Competition and Consumer Protection Act of 2014 have struck the correct balance in this area and are working well, and as a result I am confident that we will have a robust and effective set of measures in place to support and encourage a plural and diverse media.
Deputy Murphy.
Describe something as working well when it's really tested, and this is one of the tests. The acquisition, or the proposed acquisition of Celtic Media, where there's already an issue, there's already a difficulty in relation to the degree of media plurality there is. Media has to be judged across a range of platforms, and in fact it's quite an evolving sector, and that doesn't seem to have been factored in to the process. Obviously, in this particular case, you have I&M, you have Communicore, and then you have the digital platforms that go along with that. It's an unhealthy situation in a democracy where you have where you don't have media plurality, and the very fact that there is there's no prospect, as you've referred to, of there being any prospect of a retrospective action means that the very least you do is you don't make a bad situation worse. Is that something that will be considered in the context of the decision that you have to make, Minister? And will you be looking at it as more than property rights? Is it about, first and foremost, media plurality from the citizens' perspective? That will be the first, obviously, item that you will consider.
Thank you, Deputy Murphy. First of all, the proposed merger that you reference, I have 30 working days from the notification deadline of the 24th of November to conduct a Phase 1 assessment of the case. And it is solely on media plurality guidelines. Only on those grounds will I be making my assessment. And it is set out on my department's website exactly what I will be considering in that context. I haven't received the report from my officials yet in relation to it, and when I do receive that report I will read it and make the decision. And I have three options in relation to it. I can allow the merger to proceed, I can allow it to proceed with conditions, or I can ask the Broadcasting Authority of Ireland to conduct a more in-depth examination of the proposed measure. I am going to comply to the letter of the law in relation to this, as I have done with the other media merger requests that have come before me.
Deputy Catherine Murphy.
Yeah, the Phase 1 assessment, Minister, you might just read into the record what the timeline is for in the event that you do involve the Broadcasting Authority of Ireland. What timeline are we looking at in relation to that? And will you be considering the fact that there is already a threshold that has been reached, and that the very fact that there isn't the prospect of retrospective a retrospective decision, should you decide to agree to this, will that be something that will come into your consideration? Yeah, and the very fact that we've reached the 20%.
Minister, to conclude.
First of all, in relation to what I will consider and will not consider, I will consider everything that is appropriate for me to consider as set out in the 2014 Act and is set out on the Department's website. Off the top of my head, I'm not sure of the BAI timeline, because I've had a number of applications that I've had to consider up to now, none of which have been referred to the BAI. But I'll come back to you and just clarify that for you. I'm just not sure off the top of my head the exact timeline that the BAI have to report back to me on it. But I'll come back to you, Deputy Murphy, on that.
Thank you, Minister. The next question is